This wasn't just a routine docket call. Within minutes, the court addressed a capital murder venue challenge, a prison sentence, and serious jail misconduct. And before the morning ended, mental health rulings changed everything.
Yeah. And this is cause number 25 DCCR 0985 and 24 DCCR 1790. And where are we on this? What is the announcement?
Well, Your Honor, we would like to some pre-trial publicity that this case had last week. A lot of this is pre-trial publicity early on in the case. We got putting together a motion to change the venue, and I need about 3 or we want to have a hearing and just discuss this with the ADA. We haven't seen it about 3 or 4 weeks on the motion to change the venue.
Okay.
Because they had a thing was gathered last week. I think maybe we like Mr. Williams in the space, put together this motion to change the venue because of the severity of this challenge.
So I will I'll just do a normal reset, which is about 30 days.
Yes, ma'am.
If you'll get that filed, once that's filed, I would anticipate how long for that hearing to take place. How many? You would have a couple of witnesses, I would say.
Yes.
Mr. Smith in an hour or so in the morning. So what we'll do is set it, it's going to be set at normal time until we get that motion.
Yes.
Once the motion, we'll keep it on that day, and let's just make it 11 o'clock on that day. But and that way, I need to make sure, or I need you to make sure and get that motion filed, and that way we'll do it at 11 o'clock on the next court day.
Yes.
Okay.
Yeah.
Yes.
In my case, I filed a motion for discovery. Been partially satisfied. Medical records. You go on discovery page at Matthew Skin. What I want to do is file a motion specifically for the medical records. Give it to me as a PDF file, not a TIF file. Sometimes they do.
Why don't you get with Mr. Smith? If Mr. Smith refuses to do that, then let me know and I'll get involved. But if y'all talk, I'm sure if you also could probably get a thumb drive and they can download it that way. I'm sure they'll accommodate whatever you need. Get with Mr. Smith. If for some reason there's some things that you think you're not getting that you've talked to him about, let me know and we'll take care of that.
Yeah, so I'll be the point in 30 days. Reset again. Well, I'll make that same terms.
I mean, if you're going to join in that motion, I mean, we're not. I would.
That's a separate case, so.
Yeah. I think it would primarily be with regard to the capital murder case and not yours. So I would think, let's see, we'll go forward. I would assume Mr. Smith is going to want to go forward with capital murder first.
Absolutely.
Okay.
So.
Well, I'd rather, if we need them both here, I don't want them to have to transport defendant twice.
Right.
But for the next hearing, if that motion's filed, primary purpose of that motion will be for the change of venue, and it won't be necessary for you to be here.
Sure.
We'll give you notice of it. But if you just want to call and talk to Ms. Holmes and make sure what it's set for.
And they'll email me these settings from him in the 24 case.
I'm going to keep the cases together.
Yes.
Just because that's easier.
Okay.
I'm not going to have Mr. Williams coming one day on transport for Mr. Cash and one day for you. I'm going to keep the cases together. For the next hearing, I'm telling you, you're going to get a notice of it, but you don't have to be here.
Okay.
We'll take care of Mr. Cash's motion. Then we'll see where we get after that. Okay?
I'll send him from,
Yeah, this is the first I've heard of an issue with.
well.
Okay. Just, give them a call. Just, y'all work that out the best you can outside of court. And if there's any issues, then let me know and we'll handle it here. Okay?
Thank you.
Thank you. Yes, sir. Good morning, Ms. Burks. How are you?
Good. How are you?
Please raise your right hand. Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? Thank you, ma'am. Good morning. Are you Heriberto Chavez? Yes, yeah. Yes. And this is 25 DCCR 0559. Mr. Chavez is charged with deadly conduct. He's charging a firearm. And what is the announcement?
We are compatible with that judge. I'm kind of new to this case. He was at the Jefferson County Jail and then moved to LaSalle, and we didn't realize it. Anyways, got to meet with him, but need to go through the media.
Sure, okay.
So I approached me about changing my whole. I told her I don't see myself doing that on this case. So just need to make sure she has all the information so she knows where
And so what I'll do, Mr. Chavez, is reset your case for about 30 days. And that'll give Ms. DeLage time to come visit with you over at LaSalle, go over all of the discovery that she's received, and we'll get a final decision on what do you want to do with your case at that next court date. Thank you. Thank you, Ms. DeLage. Thank you. Thank you, Ms. Burge. Ms. Burge, are you here on anything else?
Next door.
Okay. Thank you. I was going to try to get you out of here if you needed something. Mr. Eckhart, you've got Alvin Wade.
After Mr. Eckhart pointed out certain impediments to our prosecution, I have decided to waive both of those in-house attorney.
Okay. Thank you very much. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Eckhart, will your client waive the formal reading of the indictment?
We do.
Mr. Wade, in clause number 25, DCCR 1648, the state's elected to proceed on count one only. It alleges that you committed a third-degree felony offense of possession of a prohibited substance in a correctional facility, and that is from July 6th, 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Freely and voluntarily.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Eckhart?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask that to everyone. Are you a U.S. citizen?
Yeah.
Yes, okay. State tenders number 1. It's admitted. Is there any evidence that Mr. Wade is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited substance in a correctional facility, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas laws to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Ryan. All right, good luck to you, sir. This is Good morning. Are you Taylor Douglas? Let me just. Good morning. Good morning. All right. Will your client waive the formal reading of the motion?
He will.
I didn't remember that. Sorry. This is clause number 25.
At this point, the focus shifted from guilt to responsibility. Probation violations inside jail can carry real consequences, and competency law requires courts to pause prosecution when mental illness prevents a fair trial.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony, and that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation in count one only by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025, which was the same date of your last hearing. And so, is that true or not true? Did you enter your plea of true to count one freely and voluntarily? And because it's actually true.
So you never even made that.
I know. That's just, and I guess once you did that, you decided, screwed, I'm gonna do whatever I want because I already know I'm gonna get in trouble because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules? You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
Ain't got no problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them? Even though you know you're going to get written up and go to prison for that? Was that worth it? Have a seat in the jury box. I'm not sure that I'm going to accept this agreement. Yeah. We need to do it in here. Okay. Are you Sally Poe? Is that? This is class number 24, DCCR 21110. Ms. Pope is charged with assault on a public servant and was previously found not competent to stand trial. I'm going to take judicial notice of the court's file. Ms. Pope was sent to the John Dunn Behavioral Science Center for competency restoration. I've received the report from them dated February 4th of 2026. It looks like we've got the trial competency evaluation report, which was done by a Leah Emery, Dr. Leah Emery and Dr. Samantha Guzman. That's dated January 29th, 2026. And findings is that Ms. Pope is still not competent to stand trial and unlikely to be restored within the time frame of the 120 days that she had there at the John Dunn Behavioral Science Center, and that further inpatient treatment would be warranted. In addition, I have a forensic psychiatry report prepared, again, January 29th of 2026. This is from Dr. Salik, Celek, also with the finding that Ms. Pope is not competent to stand trial at the present time. Also, a physician's certificate of medical examination for mental illness prepared by Dr. Celek. And the finding in that is that okay, so his finding is that she is not competent to stand trial, that outpatient treatment would be warranted is what his position is, and that the patient's condition is expected to continue for more than 90 days. That Ms. Pope suffers from mental illness that is severe and persistent. As a result of that, she needs treatment. And then I have a second physician's certificate of medical examination for mental illness. This is from a Dr. Nubia Luberis. And the finding in this report is also that Ms. Pope is not competent to stand trial, that she is mentally ill, and this finding is also that she meets the criteria for outpatient treatment. And so, is there anything else with regard to competency from the state?
Not from the state.
Mr. Rojas?
Oh, yeah.
So obviously, just for the record, everyone knows that we do not have an outpatient competency restoration program here in Jefferson County. And so I have no choice but to find that Ms. Pope is still not competent to stand trial. While the recommendation is outpatient treatment, because we do not have an outpatient treatment program for competency restoration, I'm going to order the 1 year civil commitment for Ms. Pope to the appropriate facility. Obviously, if competency restoration is attained before then, we'll get her back here. Otherwise, we'll await the report from whatever facility she goes to. All right, so we're going to try to get you some more help so that we can go forward with it.
Can I go to Slidell in Louisiana?
I'm not sure, Will. It's not up to me where they send you. It's wherever the best place is, okay? Okay. You can go back with the baby. Then, Mr. Rojas, you've got Kaisha White. No, because he's going to need it. I don't need it. He's going to be in. So he's session. You can have yeah, let's just wait. See. It's just one, right? We're going to reset Brenda Sanchez for Mr. Kimler. He's in trial over in drug court. He will be here at 1, Mr. Nichols, for our hearing. But we're going to reset his morning. And I think it's just Ms. Sanchez. Yes. Okay. All right. Are you Kaisha White? Yes. And this is 24 DCCR 2063. Ms. White is charged with assault on a peace officer. Mr. Rojas, what is the answer?
Judge, we're actually here for a competency review, or competency hearing this morning.
Oh, I'm sorry. Let me do that. Okay, let me take judicial notice. Do that. Go ahead.
She pled. Already pled this case. January 7th of 25. She didn't show up for sentencing.
Okay.
And when she was brought into custody, she was sent for competency.
Okay. So
She's never been sentenced. She's never been sentenced.
But did we get a PSI?
We did. She just didn't show up for the punishment.
What date?
1 Courtroom. Multiple lives impacted, from prison sentences to civil commitments. Each ruling carries lasting consequences, and every decision reflects the balance between public safety and due process.